2008-5016, Pima County Committee of the Arizona Libertarian Party and Pima County and Pima County Treasurer Beth Ford. Council, please announce your appearance.
Ronna Fickbohm on behalf of Pima County. Ronna.
Bill Bryson on behalf of the Libertarian Committee, Rob is another individual, so we won't be here today.
Okay, good. Thank you as well. We have a motion to strike in response. I'm ready to proceed. Are you folks ready to proceed?
Yes, Ronna.
Okay. Go ahead.
I apologize for the fact that you had to hear this such short notice. I usually find great comfort in the rules of civil procedure and in the rules of professionalism, and they avoid me having to come in front of a judge under circumstances like this. The sequence of events is, I spent quite a bit of time trying to reach an agreement with Mr. Reisner that would have avoided me needing to come here today, basically saying, won't you agree to wait until the motion to dismiss is heard, to which I get an emphatic no, followed by my, can you at least give me time to file a motion for protective order under a non-urgent sequence and have that motion be heard before Mr. Nelson's deposition is noticed? The answer to that is no. At one point I suggested we could do it 5 days after the court rules if the judge denies my motion for protective order. We finally get down late in the day on the 25th, and I have a copy of the email if you really want to see it, but hi Ronna, if you will specifically confirm that Brad Nelson will appear for deposition on Tuesday, February 14th at 9 a.m., I will send him a amended notice of deposition. An attorney reading that might read that as saying, let's move it to then so the court can hear this motion on a non-urgent basis, and then we'll follow what the court's ruling is. I have to plug in my history with Mr. Reisner, and I read that as a statement that he would use against me later if I said absolutely, and you ruled granting my protective order to say, well, the court granted your protective order, but you already agreed that Brad Nelson could be deposed. So I sent him a very unequivocal email, which is Exhibit G in my certification, saying, okay, I understand this is the status. You won't agree to put it off till after the motion to dismiss. You won't agree to put it off until after the motion of protective order. And you'll move the Nelson deposition to February 14, but only if I promise Nelson will appear at that time, which I also understand is including my promise he will appear, regardless of how the judge might rule on the request for protective order. I never got a response to that. To date, I haven't got a response to that. I haven't got an amended notice of deposition. I haven't got a notice vacating Brad Nelson's deposition. So, contrary to what Mr. Reisner has said in his motion for sanctions to you, we had no agreement to depose Nelson on the 14th, and he wasn't agreeing to that unless that deposition was happening come, water, high water, or regardless of how you rule. That just is offered up by me to show you how much time I devoted to trying to get this resolved and how difficult it is to resolve things in this matter. I also just was handed by Mr. Reisner 3 minutes ago or so his response to my motion for protective order, which is really more of a response to my motion to dismiss. It doesn't explain to you or me why there's any urgency associated with anything that shouldn't allow this case to proceed in an orderly fashion like so many other civil disputes do. There is a motion pending that, if granted by you, will resolve what remains of this case. If you agree with what I pled in the motion, and I think you should, but I'm not here to argue that motion today, no disclosure will be necessary, no discovery will be necessary. Instead of agreeing to proceed in that orderly fashion, not only does Mr. Reisner not agree to put off the Nelson deposition long enough for us to do this in a non-urgent fashion, Wednesday afternoon at 4:22, I get an email from him asking for deposition times for 2 lay people, and then 1, 2, 3, 4, 5, 6 people, some of which I don't even recognize, but all of which I assume are county employees, including Chuck Huckleberry and one of the members of the Board of Supervisors. This is in the context of motion to dismiss is pending. We never agreed on a mutual disclosure date. They sent theirs out January 12th with a when are we going to get yours letter. It's 75 pages long. I haven't had time to look at it in length, but I can tell you there's a lot of things lacking in it, such as an itemization of other statements given by these people that they want to take depositions of. And there have been lots of prior depositions on related topics. Your Honor, I think the only sane, economical way to approach this is for you to rule there should be no discovery or disclosure exchanged until after you rule on the motion to dismiss. And then, if you deny my motion to dismiss, we need a pre-trial conference under Rule 16A, where we get together and talk about a sane plan for discovery and disclosure that doesn't have us constantly running to you with things like this. These witnesses have given other statements that are related. The issues are going to be narrow. I hate to use a cliche, life is too short for you and me and Mr. Bryson to be conducting litigation in this fashion. And so I would ask you, Judge, to find that it's an inappropriate burden and expense for us to participate in discovery other than what you've ordered so far, or disclosure before you rule on the motion to dismiss. And that we shouldn't have to be here in an urgent fashion, and Pima County should be reimbursed the expense of me having to pull all that together on such short notice under Rule 37A4. Thank you, Your Honor.
Yes, sir. I believe I filed with a motion to strike a complete set of emails in a series. I asked Ms. Fickbohm for a specific date where she and Nelson would be available. And the original date I said after she had sent an email saying she was available all day on the 2nd. Then she said she needed to prepare Mr. Nelson, so I slipped in a specific date. And she were the two of them. And she said February 13, 14, 16, and 17. So I said, okay, how about the 14th? And that was the day before she filed an emergency motion saying that I hadn't agreed to change it on February the 2nd. I think what my request is, and what I'd like to nail down, is a hearing on the motion to dismiss that she's filed. It doesn't strike me that, I think it's a motion that's not difficult to deal with. And if we could get a date that would be the soonest to hear that motion, it gives me a chance to file something, which I could do this week. I think actually the last day in terms of the normal time will be the 7th of next week. But we can easily argue it on the 13th, depending on your schedule. Or if I need to put on evidence, I don't know about that. The only evidence that, I think that's unlikely. But it is very important for us to move. We've already done a comprehensive pretrial statement. So the importance of moving this along is that we have an election coming up in April. We have an election coming up in the fall. This reminds me, I was in front of Judge Miller like 5 years ago. He said, well, what's the harm? And there have been repeated elections. And in fact, we believe that at least 3 of them, the results are fishy. We think stuff's happened. And this is the kind of case where we're either wrong, but let me tell you, we can't be very wrong, because what absolutely is a given on both sides. Pima County has said in that database lawsuit that our system of computers is real easy to cheat with, and there's all kinds of ways. Chris Straub says you're only going to catch someone stupid, and we don't think they're stupid. So the one thing that's agreed upon is we have really, really lousy software, and it's easy to cheat with. That both sides are saying. So I'm saying, given that situation, and our ultimate goal is just to get an order for some changes that'll keep them from cheating. That's what this case is all about. And it's in the public interest to have that resolved sooner. It's in the public interest to say to our side, okay, you want to prove these guys cheated? Get at it. Take your deposition, prove it, get done, let's set a trial date, and let's hear this thing, and let's get the case resolved. So the only issue that's pending is motion to suppress that says, in a 12B6 where you take everything that's true, okay, we rigged $1-2 billion election, 120-year plan, and we're using the same system with the same personnel, with the same management. Gosh, how could anyone think we might do it again? That's the apparently the issue. It's hard to understand. The Court of Appeals said they didn't understand it, and it is a little hard to grasp the argument. But I think that argument needs to be set relatively soon. Get that decided, and then move forward.
Is Mr. Nelson an important cog in that wheel? I'm trying to understand the connection between, I think what I'm hearing you say is please set the hearing on the motion to dismiss soon. But I'm wondering if, in the context of this hearing, the request that Mr. Nelson not be deposed at least until after the hearing on the motion to dismiss is conducted. I think that's what I'm saying.
I don't have a problem with that.
Just bear in mind, certainly the court tries to issue rulings as quickly as it can, and the court has up to 60 days to issue a ruling in a given situation. Now, I'm not saying that's what I'm going to do. I'm just reminding everyone those are the guidelines that I'll be working with in trying to get this matter resolved as well.
I understand, but I think it's useful for you to know this case, that I can remind you that there's a real problem with us in that this case needs to be completed in time to be meaningful for elections that are coming up.
Did you have anything to add, Counsel?
I have Ronna, that part doesn't take a position for this issue.
Thank you, Counsel. Mr. Fickbohm.
I want to go back again to what the lawyers say isn't evidence, because there's a bunch of things Mr. Reisner just told you that I don't agree are true, Your Honor. Now, number one, this proposal by Mr. Reisner that I agree that Brad Nelson would be deposed on February 14th happened the day before I filed the motion. That is true. I was out of time to file the motion. The deposition was set for February 2nd. I had to get the motion filed. I understood his statement to mean, regardless of how you ruled, Brad Nelson would appear on the 14th, which would be contrary to my request for a protective order, something I confirmed with Mr. Reisner in an email that's attached as Exhibit E to my certification. So when Mr. Reisner tells you that he has given you the whole email trail, that is not right. And I will also tell you that after receiving that email from me and my motion for protective order, Mr. Reisner did contact me and say, oh, no, you misunderstood. Let's just set it then, and so that Judge Bryson has the time he needs to hear this, and if he disagrees or says he needs more time to consider the motion, we'll wait, we'll postpone it, it's not unequivocal. He didn't vacate the deposition either. With regard to the motion to dismiss, I don't have a hearing date right now. I will tell you that he may want to shorten the time that he tries to submit a response to that motion to dismiss, but I am going to need all the time that I have under the rules, which is only 5 days, 5 court days to reply. It won't come as a surprise to you that this is not the only case that I have that I'm working on right now, that I have urgent matters on, and I have given a considerable amount of time to this case in the last couple of weeks that I had set really to work on other things that are due, including a special action response I have in front of the Court of Appeals, a reply in support of another motion to dismiss, and other short deadline matters. With regard to this needs to get revised or resolved, this whole case before the April election or the fall election, number one, I say that's highly unlikely. Should this matter proceed, I think it's going to be pretty fact intensive. Number two, as I attach this Exhibit 1 to my motion to dismiss, there have been 25 elections, at least, supervised by the county's election department since the May 2006 election that brought us here in the first place. And when Mr. Reisner tells you what Pima County said or did or didn't do in the database action, I wasn't part of that, so I can't tell you for sure that what he's saying is absolutely correct. I will just tell you that my experience is Mr. Reisner is not always necessarily the best historian of things that have happened. What I can tell you, and you can tell from looking at the file yourself, is that there have been no requests by the Democratic Party when it was involved or by the Libertarian Party for a temporary restraining order, a preliminary injunction, any of the other kind of devices you would normally see from an attorney who had a case that had some urgent need for resolution because something was about to happen. And I suggest to you, Judge, that the reason that you haven't had an application for preliminary injunction, an application for a temporary restraining order, is because those would be facts-intensive inquiries, and the preference thus far of the Libertarian Party is to have everything resolved based upon statements made by their counsel about what the facts are. And I will tell you that the county absolutely disagrees when Mr. Reisner suggests to you that elections are being conducted in 2012, 2011, 2010, exactly as they were in 2006. That is absolutely false. My understanding is that there were a number of problems associated with the elections in 2006, and that the county has made a number of changes, including working together with a committee that it put together with representatives from all the political parties to get input on how to restore confidence in our county election oversight. So when he stands here and suggests to you that you should basically look past Rule 26, concerns about burdensome and oppressive behavior, and that you should accelerate things and do things on the timetable that they want to do because there's some sort of urgent need. They haven't pled urgent need. They don't even argue it in response to the motion for protective order. It's just something Mr. Reisner is saying right now. No applications for extraordinary relief, temporary restraining order, preliminary injunctions. And things are different now than they were in 2006. And if this case proceeds, that's evidence that's going to come out and be pretty compelling. Mr. Reisner telling you today that they, whoever they is, think that at least 3 of the elections were quote-unquote fishy. That is the first time I have heard that said. Judge, the counterclaim itself does not plead an urgent situation that requires exigent processing. It's not in the response to the motion for protective order. There is no reason for this case to be litigated in a way that's burdensome on you, on me, on my client, or on anybody else. And the orderly progression here would seem to be to grant the motion for protective order, stay discovery and disclosure pending your resolution of the motion to dismiss. After your resolution of the motion to dismiss, in the unlikely event this case continues, hold a comprehensive preliminary pretrial conference. I don't have my whole file with me today, but I do not recall ever submitting a comprehensive pretrial statement that to the court with all of where we list everyone who's going to be deposed and who wants to do this and who wants to do that. I know that we did do some sort of a status report, but the Libertarian Party itself only submitted its disclosure statement on January 12, 2012. And if this matter is going to proceed, there's a lot of things in that disclosure statement that are lacking that I would like to see. And requiring me to do any depositions of county employees at this juncture is just unreasonable under those circumstances. We never got together and agreed on an exchange of disclosure date. When I have these cases with other lawyers, we meet, we sit down, and I say, okay, these are the people I'm going to want to depose, these are the people you're going to want to depose, let's black out this week, let's do that, what do you want to see, what are you missing in disclosure? And you work these things out, and if you can't work them out, you go to the pretrial conference and you talk to the judge about them, and you get them worked out ahead, as opposed to every time the lawyers can't agree, and somebody schedules something anyways, even though there's not an agreement, you run in on an emergency order. This is no way to conduct the processing of this case. And I thank you for your assistance.
Let me just ask you, counsel, what it is that you were asking for, and what you plan the alternative. So, why don't you summarize and tell me what you think I should do, Mr. Bryson?
First of all, I'm asking you to issue a protective order stating that discovery and disclosure, other than the Iron Mountain depositions that you already know that were taken, is stayed pending your ruling on the motion to dismiss. If you are not, and I'm also asking that that same order could say, and following my ruling on motion to dismiss, within X days we're going to have a Rule 16A pretrial conference and get all this stuff hashed out, so we don't do this piecemeal along the way. That's the number one thing that I want. If you are unwilling to do that,
I'm not inclined to do it, just so you know. I'm inclined to let that run a parallel track to the discovery, run a parallel track to the procedural issues that you raised in the motion to dismiss. I think we can get that on the docket fairly quickly, and as we go along, you may feel like we're doing a piecemeal, but to me that gets us moving forward in a fashion that where inertia is taking us again moving forward.
well, then I'd ask you to schedule, number one, to quash the February 2nd deposition of Brad Nelson, which is still on the books.
I thought we agreed to be on the 14th. Am I mistaken in that?
You are mistaken in that, Judge.
Should we be deposed on the 14th, Mr. Nelson? Can Mr. Nelson be deposed on the 14th?
Well, sure, it's okay with me, but
Okay with you, Ms. Fickbohm?
Judge, this is just physically impossible for me. If somebody had asked me that before I got involved in doing this last minute motion the week before Friday, spending over a day and a half last week doing this, spending over half of today doing this, I just have all of these other things that people are expecting me to do that I have deadlines on. The Court of Appeals, other judges, that's just an unreasonable. When Mr. Reisner and I were communicating back and forth about Brad Nelson's deposition, I said, these dates are possible. That was in the context of, let's not be here today. Don't make me file this motion. Let's set it in a manner where the judge can hear it in the same fashion and get on down the road from there. He wouldn't agree with that. And so we never agreed to reset it to the 14th. And I have burned the time that I would have had available to do that on the 14th by going through all of this in such an accelerated fashion. Other matters that I had to cancel meetings that I had today and push them to the side so that I could be here. I mean, I made a list of stuff that I've pushed off to work on this matter. And Judge, here's the other thing. I mean, they say that they've done disclosure, but they go on and on about all these different people, and they've been deposed, and they've done this, and they've done that. They haven't listed other witness statements, other statements made by their suggested witnesses, which is one of the requirements under Rule 26.1A, I think it's subtopic 4. there's other issues with the disclosure that I'd like cleared up before anybody's deposed. I mean, the way most cases proceed is the parties agree on a disclosure date, they exchange disclosure, if there's any deficiencies, they communicate about it, and then they start setting depositions. You know, Mr. Bryson wants to do this all in a different order. And that's something that normally lawyers can get together and talk about. So if you're not inclined to grant my motion for protective order, number one, I'd like you to vacate, and he hasn't vacated the deposition, it's still set February 2nd. I'd like to order vacating Brad Nelson's deposition. I'd like to order saying that Mr. Reisner can't go over topics with Brad Nelson that he already went over when he took his deposition twice before in the database action. I asked him to agree to that, he wouldn't agree to that. And then I'd just like to set a pre-trial conference so we can get together and make a sane plan for everybody's disclosure and discovery needs, not just Mr. Reisner's immediate plan.
A couple things, just on a personal matter. She says that she had to file this emergency motion because if Your Honor issued a protective order, I would still insist on going ahead with a deposition in spite of your order saying not to. That is off the norm, off the wall. The other thing, she said, gee, they haven't filed any over these other elections. They didn't ask for a TRO, this and that. That's because the Superior Court said, Judge Harrington agreed with them. Judge Harrington said, if you have a confession, if you have total proof, if there's no question, 5 guys come in and say, we rigged that election, it was fraudulent up to the wall. But you don't do that within 5 days, the Superior Court has no jurisdiction. So how can we come in on anything, on any other election? There was an outstanding order. This case has gone to pretrial. The joint pretrial statement in November of 2008 says that Ms. Fickbohm, Pima County should file, the party should file their disclosure statement 30 days after the case comes back. So we have a detailed pretrial conference, and it's a question of getting her motion resolved and then moving ahead with the discovery. So this case that was pretrialed in 2008 can proceed.
Since it's my motion, I have the last word here. The Libertarian Party abandoned anything in a November 2008 pretrial statement when they didn't do anything to move this along after it came back from the Court of Appeals. It came back from the Court of Appeals last summer. I got their disclosure statement January 12th. So for him to stand here and say, oh, we agreed to exchange disclosure 30 days after, I mean, they didn't do that. They abandoned everything. And things have changed. It's a different situation. It's been 3.5 years, if my math is right, since that. I mean, I just think that we need, that November 2008, it's been over 3.5, yeah, it's been 3+ years. We need that type of structure again. And the other thing that I'd like to say is I've got this outstanding email from him wanting to schedule the depositions of 2 lay witnesses, I don't even know who they are, and of Chuck Huckleberry, one of the members of the Board of Supervisors, 3 other people I recognize as being county employees, one other person I'm not even sure if he still works for the county. We're just going to have one dispute after another on this stuff, Judge. Some of these people I don't think should be disposed. I think it's an exercise in futility. I think that if you're not inclined to grant my motion for protective order to the extent that I want all discovery and disclosure stayed, and you think that discovery and disclosure should be allowed to proceed, I think that we need a pre-trial conference so this is done with some structure so you're not constantly overseeing disagreements like this. It has been historically very hard to get any sort of an agreement with the Libertarian Party.
All right. Well, one of the reasons that I want to, if not create, at least encourage inertia, in other words, keep this case moving forward, is because it goes back to 2008. And this is a case that dates back to something that occurred half a decade ago, allegedly. And it is a little out of the norm for us to talk about discovery when there's a dispute about whether or not we engaged in complete disclosure. But I want us to keep moving forward and try to work this through as we go. So, we're going to order that. I'm going to grant your motion for and deny it. Mr. Nelson can be deposed, but not tomorrow, or not on Thursday. I guess that's the second, not on Thursday. Ms. Fickbohm doesn't have time available on the 14th. So we can do one of two things, folks. You can either grab a few dates, maybe for Mr. Nelson, exchange that information and pick a date. If you can't make that work, then send it to me, and I'll pick a date. This, however, is not going to establish a pattern or the norm. While we're working on disclosure and discovery, maybe at the same time, maybe not, I want us to follow those particular rules relative to how we conduct ourselves and how we get this case ready for trial before it's necessary. That last comment being made, when you respond to your motion to dismiss, if you'll send over a notice of hearing, folks will get on the docket.
I've got a notice in.
Oh, is there a notice of hearing already in there? Okay. We'll try to set it as soon as our calendar can accommodate. And that's, as you may know, I hope know, our norm. When we try to get things on the docket as quick as we can, without doing it too quick, so that people don't get a response the day before, or reply the day before the hearing. So we do try to keep things moving as do all divisions. So we'll get that done. And frankly, my inclination would be at the time that we conduct that oral argument on the motion to dismiss, I'll take up your oral motion for a scheduling a status conference. That is not to say I'm not going, I don't know what I'm going to do about the motion to dismiss. It would be, if I, of course, deny the motion, then we'll conduct that. Rule 16, scheduling the status conference. Okay? Now, as to the other individuals, as far as I'm concerned, that's not right. I hope that it doesn't have to become an issue before the court. I'm here if you need me. That's the way I view my role. And I'm confident that you do as well. But if there are individuals who can't work it out, we know where to find you. I'll say that. All right. So by the end of the day tomorrow, I want you to either have the issue regarding when Mr. Nelson's deposed resolved or not. If not, then by noon the day after, which would be Wednesday, submit to me 3 alternatives. I'll try to pick a time. We have one other individual that I have not really talked much about who's involved here, and that's Mr. Nelson. Of course, counsel would have a right to be there as well. So we've got a lot of counters we need to try to accommodate. You folks have been talking about this and working on this for some time. I'm going to assume that some alternatives have been considered as you've been walking through it or working through it. I'm going to assume, if I don't hear from you, you've resolved it, because I am going to approve the deposition of Mr. Nelson. What about Ms. Fickbohm's request that it just be one of those things not addressed in the other depositions? Well, you got that record, right?
Yes, the other depositions were in a public records case where the judge limited the questions to what was relevant in that public records case. This inquiry would be really far broader. And clearly, I have a lot I want to ask him, but I'm certainly the portions that we've covered before would really be quite small and would be intertwined with everything else. And even if I've asked him something about some procedure before, I need to find out about how the procedures are changed and what the situation is now. So I don't think it's going to be that much of an overlap. I was quite limited before. The just once on just one simple thing, which is what he did with a box and how he took it somewhere, and that's not part of this case.
Well, my only point in raising the topic is, of course, twofold. Number one, the rule contemplates a 4-hour max in terms of the time of the deposition. And frankly, because we are kind of, because the schedule is a little atypical, this is his deposition. I'm not going to decline absolutely due to cause shown to allow further or subsequent depositions to be taken of this individual. So this is your time to take his depo.
I've been doing it 44 years, and I don't think I've ever gone beyond 4 hours, so,
Okay.
you know.
Just want you folks to know where I'm coming from, okay? I've got a 3 o'clock telephonic or holding. Is there anything else folks you need from me before I let you go?
Yeah, all I say is, I heard Mr. Reisner say he doesn't intend that much of an overlap. I would just like you to say, if he's already asked him questions, he doesn't get to ask them again, the same stuff over and over again.
Folks, you have the transcripts from the last depositions. Don't ask the same questions twice. I understand there may be overlaps. I understand it's human nature. You may build upon a question or an answer from an earlier deposition. But I don't want to be the same deposition for the second or third time. I'm sensing it's not going to be. Mr. Bryson, you say you've got a lot of other things to ask, and that's fine. That's fine. Please have your offices confer with one another or confer with one another yourselves to try to get this set. If I don't hear from you by Wednesday at noon, I'll assume that you worked it out together.
And that, of course, assumes that Mr. Nelson is available for me to talk to about his scheduling, which I don't know. No.
There's a matter I want to bring up, and maybe one of our issues should help me with this. This Fickbohm gave me some dates, and as did Richardson's office for Iron Mountain's deposition. The February 1st was good for everybody. Iron Mountain's lawyer in Boston called, and turns out that the Iron Mountain guy is supposed to be in Phoenix on the 1st and can't do it that day. So Richardson gave him a new date, I gave him a new date, and Ronna says she won't agree with the new date, and have you come up with a new date?
I sent you an email this morning, Bill. That's what I mean, Judge. This is why we need a pre-trial conference.
Hang on a second, folks. It's not right. File a motion if you need to. I'll make myself available on short notice if I need to try to help you folks out. All right? So, let's do this, because you're right, it may be difficult to get a hold of Mr. Nelson. Let's extend an extra day, let's say noon Thursday.
Thank you, ma'am.
In the interim, please work together to try to figure out if you can A, get a hold of Mr. Nelson, B, schedule a deposition so that everyone can attend and make that happen. And then remind me, it'll be in the military, when we conduct the hearing on the motion to dismiss, we'll also set up a Rule 16 hearing. With that, we're adjourned. Thank you.